My name is Eileen Fleischman, and I am the Vice Dean for Alumni at the Law School and the Executive Director of the UB Law Alumni Association. This presentation on racial equity in the courts, a conversation about implicit bias in the jury selection process, is the result of a partnership between the UB Law Alumni Association, the Bar Association of Erie County, the Minority Bar Association, and the Western New York chapter of the Women's Bar Association of New York. I want to thank those organizations and the many dedicated members of the Joint Committee for organizing such an outstanding panel. You can find their names in the chat. I also want to express our deep appreciation to our panelists for sharing their expertise and thoughts on how best to advance equal justice in New York's jury selection process. This is the first of two programs that our four legal organizations are hosting together on matters related to racial equity in the courts, and that is being provided free of charge to our members and law students. A second program in the fall will be targeted to the larger Western New York community and will explore how best to diversify and expand the jury pool. Before we begin, a few brief administrative points. You will be muted during the presentation, and if you have a question at any time, please use the chat room. We will try to address the questions cumulatively at the end. At some point during the CLE, the course code will be announced and will be put into the chat room. Please be sure to catch it, as you will need it to insert it on the online attorney verification form that was included on the registration page. This form is required to issue you your CLE credit. Please also return the program evaluation form found on that page. It is now my pleasure to turn tonight's program over to our moderator, Tony O'Rourke, who is the Joseph W. Bellick and Laura L. Aswad Professor of Civil Justice and Director of the Law School's Advocacy Institute. He teaches and writes about criminal procedure. From 2017 through 2019, he was an assistant federal defender for the Federal Defenders of New York while on a leave of absence from the law school. He will now introduce you to our panelists.
Thank you so much, Eileen. It's a real pleasure to moderate this discussion on implicit bias in jury selection. Before I introduce the panelists, which I'm excited to do, because they are indeed a distinguished group, I was asked to give a bit of an overview on what implicit bias is and to try to set a frame for the discussion and try to set a tone. And I'm going to do this with perhaps an unorthodox choice, and that is to share a quote by one of the greatest litigators of the 20th century, Clarence Darrow. Can I get Eileen? I can see your face. Can I nod? Could you nod to me if you can see?
I can see it. Yes.
Okay, great. With Clarence Darrow's face on there, not the bad draft. Is that correct?
Yes.
Okay. Great. Now, I want to set the mood of the conversation with one of the most famous summations, even though this is a jury selection question, in American trial history. Clarence Darrow's closing argument in the trial of Dr. Ossian Sweet, an African-American doctor charged with murder for shooting at a white mob in Detroit who was attacking his house in 1925. And at the close of this racially charged trial, Clarence Darrow offered the words that you see before you. Now, gentlemen, I say you are prejudiced. I fancy every one of you are, otherwise you would have some companions amongst these colored people. You will overcome it, I believe, in the trial of this case, but they tell me there is no race prejudice and it is plain nonsense and nothing else. You need not tell me you are not prejudiced. I know better. We are not very much but a bundle of prejudices anyhow. All I hope for, gentlemen of the jury, is this, that you are strong enough and honest enough and decent enough to lay it aside in this case and decide it as you ought to. Of course, Darrow was calling jurors to account for their overt racial prejudices. And our topic today is implicit bias, not in closing arguments, of course, but in jury selection. But as our discussion may reveal, it is sometimes difficult to untangle these two topics. Implicit bias suggests that people can act on the basis of racial prejudices and stereotypes without them intending to do so in a completely unconscious way. And there is indeed a wealth of research showing that such unconscious biases operate on all of us in significant ways. But on the other hand, there is a growing body of research showing that implicit bias may not explain most of the troubling patterns we see in policing and indeed in jury selection, as well as in other aspects of our criminal legal system. Indeed, this research argues that explicit bias, or let me put it this way, indeed, this research argues that explicit bias, overt racial bias, can explain much of what implicit bias purports to explain. If you want to get a sense of how people will behave, you could ask them what they think of people of a different race or gender, and that will do much of the explaining for you. So how much does implicit bias play, how much of a role does implicit bias play in jury selection? How much do explanations involving implicit bias serve as a polite way of avoiding the degree to which white supremacy and good old-fashioned explicit bias might suffuse our criminal legal systems, including at the jury selection stage? How do the questions of implicit bias and juror diversity intersect? You may hear a range of perspectives on these questions today, and I look forward to the discussion, which I don't want to delay by expounding further on these issues. With us tonight is the Commissioner of Jurors for Erie County, and a federal judge, a prosecutor, a state judge, and a criminal defense attorney, and they will each give their perspectives on implicit bias on the jury selection process, whether it affects outcomes, and what we can or should do about it. Speaking first is Dr. Christine Ferro, Acting Commissioner of Jurors for Erie County. Dr. Ferro's primary responsibilities include providing qualified trial jurors to all courts within Erie County, as well as summoning jurors to serve for grand juries. Further, she oversees impaneling, determines the number of jurors to be summoned, collects and analyzes county statistics, and explains procedures and other aspects of jury service. Next, we'll hear from Judge Jeanette Ogden, who is a New York State Supreme Court Justice for the 8th Judicial District. Judge Ogden is the chairwoman of the 8th Judicial District's Committee on Women in the Courts, Gender and Racial Fitness. She serves on the Appellate Division's 4th Department's Character and Fitness Committee, and presently teaches a course at the law school on mental health issues in the law. Judge Elizabeth Wolford is a United States District Judge for the Western District of New York. In May 2013, upon the recommendation of US Senator Charles E. Schumer, President Barack Obama nominated Judge Wolford to her current position. She was confirmed by the US Senate in December 2013. Ms. Holly Tucker is an assistant district attorney at the Erie County District Attorney's Office, where she is a member of the Domestic Violence Unit. She prosecutes cases arising between domestic and intimate partners. And Mr. Robert Ross Fogg is a trial attorney with a solo general practice, focusing in the areas of federal and state criminal defense, immigration, and personal injury. Before we hand it over to Dr. Ferro, just a few housekeeping points. A reminder to please keep yourself muted. If you want to ask any questions, I ask that you send me a personal chat with succinctly framed questions, and then I will review those questions and then call on the person who asked it to ask it. And with that, we will begin with Dr. Ferro.
Thank you so much, Tony. Good evening, everyone. So as we talk about the jury selection process, I think it's important to provide everyone with some background information on the path of the juror, where they come from, what they actually go through before they arrive at the courthouse. So just to put things in context, in Erie County, we summons approximately 56,000 jurors annually to cover our civil, criminal, as well as our grand jury proceedings. So when I describe jury selection to folks, I think of it in 3 stages. Stage 1 consists of compiling that master list. Stage 2 is the qualifying and summoning process. And Stage 3 is the actual voir dire process. The Commissioner of Jurors is responsible for stages 1 and 2, and the other panelist that you'll hear from is responsible for stage 3. So briefly, let's take a closer look at stage 1, and that's compiling the master list. So we all know that litigants have a right to jury selected from a fair cross-section of the community. So how do we actually meet that fair cross-section requirement? Basically, where do the jurors come from? So each year in New York State, the court system requests lists from 5 state agencies, and those are the agencies in the names that we use to create our master list. Those agencies are New York State Department of Tax, Department of Labor, Department of Social Services, Department of Motor Vehicles, and the Board of Elections. I would like to add a lesser known fact that in New York State, you can actually volunteer for jury service as well. This gives an opportunity for those folks that they may not appear on one of the source lists to participate in the process. I would also be remiss if I did not mention that New York State has one of the most comprehensive source lists to get names of potential jurors. Because folks, their names may appear on more than one list, any name that's a duplicate is removed. This is extremely important when it comes to random selection. And for those that may not know, randomness is truly the hallmark of the jury system. So that's basically stage 1 in a nutshell. We'll briefly take a closer look at stage 2, which is the qualifying and summoning process. In New York State, we use a 2-step process for qualifying and summoning. So first, from that master list that I just mentioned, we need to determine who's actually qualified. Individuals are selected at random from that master list to receive a qualification questionnaire. And this is just to see who meets the statutory requirements to be a juror. Just so we're aware, the statutory requirements on the state side for someone to be eligible to serve as a juror is they would need to be a US citizen, need to be a resident of Erie County, 18 years of age or older. There is no upper age limit on the state side. They would need to have the ability to understand and communicate in English and not have been convicted of a felony. However, those who have a certificate of relief of civil disabilities or a certificate of good conduct would be qualified to serve. As the commissioner, I am not allowed to pre-screen the jurors outside of those statutory requirements. And the qualification questionnaire does not ask any demographic information about the juror outside of those statutory requirements that I just mentioned. And I would like to share with everyone that everyone who's eligible must serve. So those who meet those statutory requirements are then entered into what we call our qualified pool, and then they're eligible to receive a summons within 18 months. So that brings us to step 2, the actual summoning process. So based on the needs of the court, individuals from that qualified pool are then selected at random, because again, everything that we do on the jury side is at random. They're selected at random to receive a summons. As I mentioned earlier, in Erie, we summons approximately 56,000 jurors annually. There's no automatic exemptions. There's no preferential treatment given to anyone, not based on your age, your profession, your status as a student, or being a small business owner. If you meet those requirements, you are required to serve. Because we do mail out the summonses 3 weeks in advance, if someone isn't able to serve on that particular date that they are summoned, as the commissioner, what I can do is work with you on a date that's more convenient for you, but not to exceed 6 months. Any reason outside of, let's say, medical that you feel would prevent you from serving needs to be addressed with the other members on the panel, whether it's the judge presiding over the trial or if it's the trial attorneys. And that all takes place during the actual selection process. Again, as the commissioner, I can't address anything with the juror outside of those statutory requirements. So this basically means that all the jurors that arrive at the courthouse, they have met those basic qualifications to be a juror, and they are ready to proceed to stage 3 of the jury selection process, which is the actual voir dire. But before I go on to that, I just wanted to tell the audience a few things that we're doing on the state side to streamline our overall process. We have a call-in standby procedure. That means jurors will only report to court when they're instructed to do so. And to make things more convenient, the jurors can now sign up for text and email alerts about their service. I think it's important to mention in Erie County, your frequency of service is only once every 8 years. We utilize a one trial experience. So for those selected as jurors, your length of service is equal to the length of one trial, and that's with the exception of grand jury. And if you appear at the courthouse, and let's just say you're not selected, then your length of service equals, in most cases, just that one day. Our juror per diem fee, it's $40 a day. And I will say that's one of the highest per diem fees in the United States. But however, my counterparts on the federal side, they're higher than us by about $10. So in closing, I'll say this, the judges presiding over the trials must know that the panel of jurors that appears before them have been handled with high integrity. Therefore, it's my role to do just that by upholding all aspects of the judiciary law as it pertains to jury service. So I look forward to any questions that you may have at the end, and I'll turn it over to Judge Ogden.
Good evening. I'm Judge Jeanette Ogden, and I am a New York State Supreme Court Justice. And although New York State judges have general jurisdiction, I preside predominantly over civil cases. Prior to being elected to the Supreme Court, I served on the city court, and I served in the capacity as an acting county court judge. And in that capacity, I presided over the trials of criminal court proceedings. And the jury selection process is quite different between the two. In the criminal process, I supervised the voir dire, which is the questioning of the jurors. In the civil process, I do not. When the jurors come to me, they come as a panel. And there is a difference in that process, but that's something for another day. What I would say is that jurors not only instinctively pick up on the way that other attorneys treat the other litigants, but they often express explicit biases that are sometimes addressed and sometimes not addressed. In the criminal realm, there's something called the Batson Rule. And I'm going to leave that for others to discuss. But the Batson Rule prohibits certain discrimination, certain exclusion of jurors, and allows the lawyers to make those arguments to the court. There is no corollary in the civil realm. However, there are things that a judge can do, but more importantly, when the jurors come in, they see a movie. And unfortunately for us in the state court, our movie doesn't necessarily include instructions on implicit bias. And I believe that everybody has a type of implicit bias. Also, the pattern jury instructions are what the lawyers use when the judge is giving instructions to the jury, preliminarily before the trial begins and at the exclusion of the trial. There is no civil pattern jury instruction on implicit bias. But the federal court does have one, certain federal courts. And what I do and some of my colleagues have done is we have borrowed certain pieces of those instructions and incorporated them into our preliminary instructions. And I share those preliminary instructions and final instructions with the lawyers, and the lawyers are given an opportunity to participate. We can tweak the language, and they can make submissions on instructions they would like for me to give to the jurors. But what I find is that at the end of the day, what I usually say to lawyers is that you have to know and remember your value. And you have to command the room and appear to be competent and in charge, no matter what your ethnicity is, or no matter what your gender is. Because people are going to have these preconceived notions about who you are as a minority, who you are as a minority lawyer, who you are as a female lawyer. And you have to be mindful of that. And it is your responsibility to overcome some of those preconceptions by being prepared. And if you are prepared, you can be competent, and your case will flow in such a way that that might allow you to overcome some of the obstacles that are based upon implicit biases. And at the end of the trial, you can always make your motions, which lawyers are going to do anyway. And if you think bias of any kind has played a part, you can always ask outside of the presence of the jury for a sidebar with the judge to discuss those types of things. Now, we have in the state court system specific rules that preclude lawyers from making racial and sexual comments toward their opponents during the course of a trial. But these types of things you have to be mindful of, because at the end of the day, in my opinion, you're really not going to change the person's biases. But what you might be able to do is to be able to make a difference and make sure that they're not playing a part against your client. And in the voir dire process, it is your responsibility to ask the questions that can bring out those biases. And you have to do so in a way that does not alienate the rest of the jurors. But you have to do it. And sometimes you're going to be asking uncomfortable questions. But you have to be willing to ask those uncomfortable questions if you're going to get a jury that is fair and is going to do the things that that jury is there to do. And so that, unless there's questions, and I'll hold them, I know they're being held for the end of the program, I simply say thank you.
Thank you, Judge Ogden. And before we turn it over to Judge Walford, I've been asked by Eileen to give the secret code for your CLE, and that is jury, which I believe Eileen will type into the chat right now. Judge Walford, please.
All right, thank you. Good evening, everybody. My name is Elizabeth Wolford. I'm a U.S. District Judge in the Western District of New York. I want to first touch upon jury selection in federal court, which is a little different than what's been described for state court. So our district consists of 17 counties. And in Buffalo, we summon jurors from 8 counties. In Rochester, we summon jurors from 9 counties. And the geographical region of our district necessarily creates challenges in terms of having a racially diverse jury pool. Our court has taken steps in an attempt to increase racial diversity. In 2016, the New York State legislature, and then it was signed by the governor, adopted and enacted legislation allowing federal courts broader access data sources for jury lists. These data sources were already available in the New York State court system, but federal courts could not access them. And this legislation allowed our court to go beyond just the voter registration and DMV records And we now also solicit prospective juror data from public assistance information with the New York State Office of Temporary and Disability Assistance, unemployment recipient information from the New York State Department of Labor, and certain taxpayer information from the New York Department of Taxation and Finance. I can share with you that the Western District of New York pulls data from the broadest sources of material as compared to any other district court, federal district court in New York State. In other words, our resources are broader than the Northern District, Southern District, or Eastern District of New York. Now, a diverse jury pool, including one that is racially diverse, is important for all types of cases, but concerns about racial diversity in the jury pool are probably greatest with respect to criminal cases. In preparing for this program, I went back and took a look at the criminal jury trials that I've conducted since I became a judge 7 years ago. I've conducted criminal jury trials in both Rochester and Buffalo, and the numbers have been pretty evenly split between those two cities. 63% of those criminal jury trials, in other words, well more than half, have involved cases where at least one of the defendants going to trial was an African-American male. So the reality is that no matter how much success we have in pulling prospective jurors from a fair cross-section of the community, because of the population that we're pulling those prospective jurors from, the racial makeup of our jury pool is probably not going to correspond to the racial makeup of the defendants in criminal cases. As a result, exploring both actual and implicit or unconscious bias during jury selection is critically important. I've always included actual bias questions during my voir dire, and in federal court, which is different than state court, the judges in criminal cases do most of the voir dire, or really all of it. In civil cases, it varies by judge, but the judges definitely are more involved in the jury selection process than in the state court system. I will say, as I've become educated and more aware of implicit bias issues, I've also come to better appreciate the importance of exploring implicit bias in jury selection. Exploring for actual bias during voir dire is really different than exploring implicit bias. If somebody has actual bias, then they should be excused for cause. But having unconscious bias is different. Everyone, in my opinion, has unconscious biases. And therefore, what I think is important to cover in voir dire is alerting the prospective jurors to the fact that it exists, that everyone has implicit biases, that you can be a person who has deeply held convictions against racial discrimination and racial bias, and yet still have unconscious bias. I think it's important during the voir dire to have the judge instruct that it's important during their service as a juror to check in with themselves and evaluate their decision-making and ask themselves, would they evaluate the evidence the same way if the defendant was a different race or gender? Or would they evaluate the testimony, for instance, of a witness the same way if he or she was a different race, a different gender, different age, etc.? During voir dire, I think it's helpful to get prospective jurors to commit that they're going to be willing to do that and explore whether anyone believes that they would not be willing to do that. Depending on the answers, there may be a basis for a cause challenge. Now, the reality is with any kind of bias, especially racial bias, it's challenging, I think, to get prospective jurors to give honest answers about these issues. And one of the tools, I guess, that I have found helpful is to tell jurors that the voir dire process is a fluid process. The fact is, you're raising these issues with prospective jurors for the first time, and oftentimes they've not thought about these issues before showing up in court. They're nervous about jury selection. They're in a foreign environment from their everyday lives, and you're throwing all these questions at them. And I think it's very important to remind them, as I said, that it's a fluid process. And just because we've covered a topic and go on to another topic does not mean that we can't go back and revisit a topic if something comes to their mind as they give more thought about that. And I specifically remind prospective jurors of that fact during my discussion of race and bias. And I've had prospective jurors later on in the voir dire process then come up during a break or during even after lunch, for instance, and bring to our attention, to mine and the attorney's attention, a concern that they have about racial bias that was not addressed during the portion of voir dire during when the topic was discussed. Now, my personal opinion is that the best way, the most important way to guard against unconscious bias is during the jury selection process. I think what is discussed during voir dire sticks with jurors throughout the entire trial. And I'm saying that based on discussions I've had with jurors after verdicts are returned, when they'll mention to me that during their deliberations, they thought about something that was said to them during voir dire, whether it was the importance of listening to each other or keeping an open mind. Now, that said, I think it's also important to cover issues of bias in both preliminary and final instructions. As Judge Ogden mentioned, some federal courts have form instructions that include instructions on implicit bias, and I include some form of those instructions in both my preliminary and final instructions. Now, another very effective tool, I think, can be a videotape that is shown to prospective jurors at the commencement of jury selection. This is in addition to the general orientation video. Some courts, I think the most prominent one is the Western District of Washington, has a video that is shown to prospective jurors on the issue of bias, and more specifically, implicit bias. The one from the Western District of Washington, it's only about 10 minutes long. And in my opinion, it's very well done. And with permission from that court, other courts are allowed to show it to prospective jurors. There's also one that's similar that was created by judges in both federal and state judges in the state of Oregon. Now, one of the good points that is made in the Western District of Washington video is that simply having good intentions alone is not enough. And an important first step in preventing unconscious bias influencing the decision-making process is to be aware of it. In other words, encouraging jurors to have conscious awareness of what goes into their decision-making so as to prevent unconscious biases from influencing those decisions. So with that, I look forward to your questions at the end, but I'm now going to turn it over to Holly Tucker.
Yes, okay. So my name is Holly Tucker, and I am a prosecutor with the Erie County District Attorney's Office. I have been a prosecutor for 23 years, and for about 15 of those 23, I have been doing nothing but domestic violence cases. As anyone knows who has worked in the world of domestic violence or intimate partner violence, those crimes occur behind closed doors, and rarely are there any witnesses to those crimes. So often it's a lot of he said, she said, and many, many of those cases result in jury trials. So when we talk about the jury selection process, I have absolutely no control over the panel that is brought into a courtroom, which would be the first time that I would actually see them. And I stress to all jurors when I'm speaking to them, so we're in the state system where the judge would do initial questioning, and all judges are different. Some judges will limit us to 10, 15, 20 minutes. Others won't limit us at all. And in these cases, our questions are very case specific And they have to be that way because really my goal is to pick a jury that is going to be fair and impartial to both sides, not just to the people, but also to the defense. So we don't really know when we're asking prospective jurors questions if they're really telling us the truth. It is important, as Judge Ogden noted, that you need to be prepared, you need to be professional, and you need to ask very specific questions and let the jurors understand that this is the only opportunity that I am going to have to speak with you instead of at you. So, this is the time right here and now that you would want to bring up any possible questions or concerns that you might have. So when you're talking about implicit bias, it's something that is very difficult to uncover. I think that you ensure that people are being open and are answering your questions. Usually it's really a gut instinct thing for me. Either there's been questions answered when the judge was doing their initial questioning that I want to do some follow-up based on knowing what my case is all about. And it can be difficult in terms of what your case is about. Before I was doing domestic violence, I prosecuted a gang member that was very high up in the Bloods, and when the Bloods and the Crips were a big thing. And ultimately, he liked other men sexually, but he liked men who lived as women, but were still men. And this would have really destroyed his street credibility, as I'm sure you could all imagine. It was very difficult. And what he did was he robbed his lover at gunpoint, put a gun to his head and robbed him. And it was difficult picking a jury because I needed them to understand the relationship between the defendant and the victim on that case. And if you have somebody that is possibly homophobic, or they believe that, there should only be heterosexual relationships, that men shouldn't be with men, women shouldn't be with other women, obviously those would be the topics or the kinds of things that I would be trying to uncover. But always, always my goal is to pick a fair and impartial jury that will be fair to both sides and that will be able to follow the judge's instructions. So, for example, just as a hypothetical, if you had a woman that was a domestic violence victim for 10, 15, 20 years, and all of a sudden she snaps and she kills her abuser, the average person knowing the history to that case is going to feel sympathy and be sympathetic towards that victim who now sits in the defendant chair accused with murder or homicide. And you as jurors have to follow the charge from the judge and follow the law. And can you do that when you know deep in your gut, even though you know to the letter of the law that she is guilty, you are perhaps silently happy that she killed her abuser and you do not want her to spend 5 minutes in jail. So, there's lots of different angles and ways that you actually would look at these things. But for me, when I go through these things, either people are very overt with their bias, whether they are conscious that they are making that aware to everyone else in that room or not, or they are not. And it's difficult to uncover, and you do the best that you can in the time frame that you have, which oftentimes can be very limited. So I don't know what we can do. What are the outcomes of implicit bias? And I don't know if those outcomes are the same for me, a woman of color who is prosecuting just criminal cases, and I prosecute all races. And I don't care what race that person is. If I believe that they committed that crime, then I believe that they are guilty of that crime. And my intent is to have them be found or to prove to that jury by the facts and the evidence of the case that they are in fact guilty. Nothing to do with the color of their skin. So how can we advance diversity and inclusion in jury selection? What can we do about implicit bias? I think we need to educate and we need to engage the community as to why they feel so apprehensive about jury selection, serving on a jury, and doing what really is their duty. And I also think that perhaps we can do better in terms of the list that we are drawing from, and recognizing that many minorities do not have driver's licenses. Many minorities are not registered to vote, et cetera, et cetera. So I'm not sure what the answer is, but I welcome any suggestions, and I thank you all for letting me participate in this very important discussion. And I will now turn it over to Mr. Fogg.
Well, thank you, Holly. My name is Robert Ross Fogg. I'm a predominantly criminal defense attorney in New York State. I have been practicing in the area of criminal law for approximately 20 years. And as far as criminal defense, I'd have to say about 17 years. I practice in state court and federal courts. I have practiced throughout the jurisdictions of New York State, in several counties in the northern part, the centered part of New York State, and the like. I can tell you, to answer the question of, is there implicit bias in jury selection? The answer is definitively yes. Does it adversely affect the outcome of the trial that I am representing a client? The answer is definitively yes. The question of racial diversity on jury pools throughout New York State, I will tell you that there is no diversity. And I can point to a few things. Every time I have a client, my client will tell me, aren't I entitled to a jury of my peers? I have to explain to my client that they're not entitled to a proportionate number of jurors that look like them. What they are entitled to is a jury pool selection that closely reflects the percentage of the population in which the crime was committed. Now, if you take that in perspective, let's say Buffalo has 11% African Americans. Let's say the jury pool selection consists of 100 people. Therefore, we're looking for 11 African Americans. Now, sometimes what happens is we collectively bring minorities together as Asians, Southeast Asians, and African Americans, and try to consider them part of the pool. But for the most part, during the selection process, we may never get to the 11. And as it goes, you pick from however the court picks the jury, prospective jurors to be questioned. We may never get to the only 11 that might be there. And then we take what Holly was talking about. Why do some African Americans not want to participate, or they're not there at all? Well, African Americans are just like everybody else, and they go with the very, very same common theme, that a person who sits on a jury pool or jury selection is one not smart enough to get off the jury selection. And they do exactly what everybody else does, and they try to get off or try to avoid. Unfortunately, because of the lower percentage, we cannot risk that. So there has to be some sort of education about their civic duty to be part of a jury selection and pool. And I think that goes to community outreach. It has to be done, because there are many African Americans that I've represented that go to trial with one or 2 African Americans on it. Now, that hurts them, and it hurts them adversely because we're talking about a person's life and liberty. Now, the question comes up, and I have to explain, and we always talk about why is this a problem for you, my client? And that is because of explicit bias and implicit bias. Now, this panel is based on implicit bias in jury selection. So the question then becomes, what is implicit and what it means? But I'll tell you, implicit bias is simply a term of art. It's used in philosophy, psychology, and social sciences. And it's used in a variety amount of ways. And there is no universal or widespread agreement as to its understanding or its meaning. But arguably, the most common understanding is that it's unconscious attitudes. Now, generally, people hold 2 distinct attitudes in mind toward either an object or person or an issue, and that would be explicit attitudes. And they're commonly identified by what somebody verbally reports about their attitudes, and implicit attitudes. And that's usually what people are unwilling to say or unable to report. Now, what we usually do is we usually look at implicit bias in jury selection as a thought of unconscious tendencies for or against a race. And it's a social cognitive exercise that people go through. And the people may not be aware that they're going through it. And in jury selection, what we have are people who don't want to be perceived as bad people. And we have people who are trying to suppress that which they already know or believe through their society, their community, how they were raised. And they try to suppress that so they don't be perceived as being a bad person. Now, there are many examples of, I guess, implicit bias. I mean, we can see it every day. Basically, they're seen in stereotypes. In other words, we evaluate or equate Black with being bad. You see a Black man, you think scary and you try to avoid him. There's also the implicit association between Black men and guns. And this would explain some of the police shootings that we've seen of unarmed Black men. In other words, you are likely to believe from your society, from how you were raised or what you've seen, that Black men are more likely to carry guns than white men. And if that's the case, a person who's Black or has dark skin carrying an innocuous item might be perceived as having a gun automatically by the individual because of their own implicit bias, which they are not aware of. So to get to the types of, I would say there are race, gender, religion, profession, class, disability. There are many types of biases that we face and that we see every day. In insurance premiums, actuary risks charts, real property of sales in certain neighborhoods for buyers and clients. Also in prosecutors, who what I have seen, and no offense to Holly or anyone else, but from what I have seen, have routinely removed prospective Black jurors from juries. Now, the removal is rooted in an implicit racial bias. Now, it may be based on questions that are formed as to prior contact with law enforcement or living in a high crime area, but that's also a sense of implicit bias. There's also the implicit bias of defense attorneys. Well, we don't want this white person on, or we don't want this Black person on. So even defense attorneys are subject to the same implicit bias as jurors, and that all affects how you select a jury. Now, when I listen to, when I see how I can affect implicit bias, or at least take the effect away from my client, the only place I can do that is through voir dire, which is a French word, which is to see or speak the truth. And this is the chance in which I and the prosecutor get a chance to speak directly to the jurors, the prospective jurors. And this is a chance where we can actually hear their voices. And the purpose is to seek out their attitudes and their beliefs. But we have to remember that most people do not self-report their beliefs. So to specifically ask a juror "Are you a racist?" is one in which it directly implicates the bias, and therefore the person will protect themselves, will not truthfully report, so they're not perceived as wrong or bad, and will never get the truth. So therefore, what a person would have to do is ask questions designed to get behind the attitude, as such like analogies or analysis that suggest the bias, so that they can truthfully come forward, and then we can evaluate that person's bias. Now that's the power of voir dire. And we also have to remember that in voir dire, we have challenges. And the challenges are the way to remove a juror. We have challenges for cause, and of course, a lot of times that will be for the racial bias or some other material reason. But a lot of times that is the explicit bias that we have. And a lot of times the judges will control that and everyone will see that. The other part is the implicit bias that we're looking at, and that's where we use peremptory challenges. However, the peremptory challenges are a thing of contention as well, because peremptory challenges are where attorneys can remove a prospective juror without any reason at all, and thereby actually furthering the implicit bias of the party, because we don't have to report it. Usually in New York State, with A felonies, you get 20 peremptory challenges. B and C felonies, you get 15. Other felonies can be 10. A and B misdemeanors can be 3, and that's found in CPL 270.25. In federal court, on death penalty cases, you get 20 on each side. In federal court, on felony cases, you can get 6 for the government and 10 for the defendant, and that would be usually jointly as well. On misdemeanor cases and felony, you get 3 for each side. That's usually found in the Federal Rules of Criminal Procedure 24B, 1, 2, and 3. Now, relying on self-reporting, you actually give the juror the ability to respond strategically. So one of the things that we have to do as defense attorneys and cross-examiners, once we're examining or speaking to the juror, we have to somehow minimize that person's reliance on introspection and their ability to respond strategically. So in order to do that, we need to ask those specific questions about, and not necessarily their background, or not necessarily based on their geographic location, but sometimes that could be in and of itself a racial bias that we have as prosecutors or defense attorneys. But we need to somehow identify those jurors and their attitudes, and make sure that they don't, find the ones that don't align with your client's case. What we have to do is also establish the foundation for their bias. So this way we can use the peremptory strikes or challenges of cause. Now, the problem that we have is, strategically as a defense attorney, is that a lot of times we do not want to actually target a juror, allow them to tell us information about them that puts them on my side. And the reason why is because Holly will look at that and Holly will go for a preemptive strike and remove that person. That's why I call jury selection actually jury deselection, because we are actually removing jurors as we are speaking to them. Once we get a set of jurors placed before us, we remove them. Whomever is left, that's our jurors. So therefore, it is incumbent upon the litigant or the litigator to actually remove those jurors that you know will not be on your side of the case. But you have to do it in a strategic way, which they don't have the ability to think about it, and that counsel for the other side doesn't necessarily remove those jurors, prospective jurors, that you would like to have. Now, those are the problems I see, and they affect the life and liberty of all my clients. I've had several cases where the implicit bias, the juror would not show implicit bias. The questions that will come from them will be whether or not they could, fairly and unbiasedly make a decision and a determination based on the facts of the law. They'll all say they do, and they all will say they will, but you'll know that there is an implicit bias underpinning. And based on the fact that they've made that allocution, the courts will allow them to come on. So therefore, it's incumbent upon the litigator in that perspective to pull out the bias, to actually be more exacting and pull out the bias. But you got to understand, there are some jurors who just want to be on that trial and will lie to you every single time. And there are other jurors who don't want to be, and they'll lie just so they can see, because everybody sees what's going on. You know what the answers are to get you off, and they will actually give those answers just to be removed. But sometimes those answers aren't good enough to be removed for cause, and therefore you have to rely on peremptory challenges. It's a strategy, and it's not a science, but it is a strategy, and one that has to be mastered. It has to be considered. And there at that time, there's nothing as a defense attorney, there's nothing that we can do to stop the implicit bias that stands before us and that truly damns every client that I have. I thank everybody for listening. If you have any questions, please feel free to ask, and we could discuss it. Thank you.
Robert, thank you so much. And thanks to all of the panelists. There are some great questions that people have already sent to me in the chat. So I will withhold my urge to jump in with my own and turn it to, I will turn it first to Cheryl Myers-Booth, who has a question that I think is probably best directed to Dr. Farrow.
Hi, Doctor. I just wanted to know whether there were any statistics kept about the race of jurors who are in the qualified jury pools, and if so, where to find those statistics.
There's no statistics on the race of folks in the qualified pool. However, when a prospective juror does report for service, that's when we collect the actual demographic and demographic card, and that's anonymous. And that report is actually public. It's called the Section 528 report, and it breaks down the jurors served by age, race, ethnicity, and gender for all 62 counties in New York State.
Wonderful. And our next question comes from Robert Zucco. It is a question that I think many people could speak to, but I think perhaps Judge Wolford especially. And if you wouldn't mind unmuting yourself.
Okay, sorry.
That's okay.
Well, I would like, we talk about the Batson rule as being the primary tool to fight bias, but could you comment on the adequacy or inadequacy of the rule to address implicit bias, and the adequacy or inadequacy of the rule to address bias within the jury panel?
Well, I guess I wouldn't characterize the Batson rule as probably the best tool to address bias. I think the voir dire questioning and eliciting information from the jurors is the best way to explore whether or not prospective jurors have a particular bias. I mean, a Batson challenge, it's not an easy challenge for a defendant to make. And the defendant first it's a burden shifting approach in federal court. And the defendant first has to come forward with a prima facie case that there is a basis to conclude that the peremptory was exercised because of a race-based reason. And if the government comes forward with a neutral reason, it's very difficult with just one challenge to successfully establish a violation of Batson. If there's a pattern that's been established, and there's been more than one racial minority struck from the jury, then it may be a easier means by which to be able to establish it. But I don't think it's a easy process for a defendant to meet a challenge just based on the structure of the rule. And that's why I think from a defendant's perspective and from a prosecutor's perspective, eliciting information from these jurors, getting them to talk during the voir dire process, finding information from them, and then excusing people based on cause is, I think, a more effective way to go about trying to eliminate prospective jurors who do have any bias, whether it be actual or implicit, that they're not going to be able to set aside in their consideration of the case.
Judge Wolford, if I could exercise a moderator's privilege to ask a follow-up to that. I think Robert gave some great advice in terms of the tools that are at attorneys' disposal during voir dire to try to target both implicit and explicit racial bias. Judge Ogden basically exhorted attorneys to do this, but of course, in the federal system, attorneys have far much less lead ability to conduct voir dire unless you're in front of one of the rare judges who would be amenable to a motion for an attorney conducted voir dire. And many judges, district court judges, are, like you, sensitive to the problems of implicit and explicit bias and conduct voir dire with that in mind. But forgive me for saying perhaps some are not, it just doesn't occur to them immediately. What tools are there at an attorney's disposal? What sort of motions would you like to see attorneys filing at the voir dire stage? What is in the attorney's hands rather than the judge's hands in the federal system?
Well, in the federal, first of all, with my personal practice, I entertain requests for attorneys to conduct voir dire in civil cases. In criminal cases, I spend a full day questioning the jurors. Actually, in this pandemic, the last jury selection I had took 2 days because of the challenges with group gathering because of COVID. So I don't personally think that the process is less thorough by any means because the judge is asking the questions. But what attorneys need to do is make sure in your pretrial filings that you put any questions in there that you want the judge to ask. It can be error for a judge not to cover a particular topic that an attorney is asking that judge to cover during the jury selection process. So oftentimes I don't necessarily see robust filings from attorneys in terms of the questions that they want me to cover with respect to jurors. During the voir dire process, I would say make sure you put on the record any questions that you think have not been asked that you think the judge needs to cover. And again, it can be error if the judge does not consider a reasonable request to ask a particular question of the prospective jurors. So the rules are clear in federal court. The judges do have the ability and the power to control the questioning, to be the ones that are the spokesperson, so to speak, and asking the questions. But you have to consider requests from attorneys. And I think attorneys, frankly, should take more advantage of that opportunity than they do.
Wonderful. And the next question, again, could be answered by many people, but I think perhaps Judge Ogden, given her great deal of service in a number of civic bodies, might be the best person to opine. And it comes from, forgive me if I mispronounce your name, Cecile Dorlier. And if she is not available, I will ask it. Has there been any discussion regarding the legal community introducing the jury selection process to secondary education curriculums, a sort of civic engagement with the student body? So I would ask that first to Judge Ogden, and then if she wants to pass on it, if anyone has anything to offer on that. What sort of civic education at the has been offered or has been discussed?
I know that in the state system, they go out to the high schools and they go out to the churches and they discuss participation in the jury process. Now, incorporating that into the actual curriculum would be something that the Board of Education, the various community boards of education would have to agree to. And I don't know if that is done. But in answer to the other question, I would like to say that the Batson rule is totally, in my opinion, totally inadequate as a tool to address implicit bias. It will address explicit bias and you can open the door. But to deal with implicit bias, I don't think the Batson rule is adequate to deal with it.
Thank you.
Tony?
I'm sorry.
Tony, if I can just answer the question about civic engagement and outreach at secondary.
Please.
As part of my role in the Commissioner Juror's office, is a big component is the outreach that some of the other panelists talked about. And I have done outreach with high school students, those who will soon be 18, to educate them on the importance of jury service. And like our judges in the 8th, they also participate as well. So, and that's not something that's done through the school. That's something that's done through our very own outreach program in Erie.
Wonderful. Thank you for jumping in. And I encourage any other panelists to jump in and in just the same way if they want to follow up on any questions. We have another question that comes from Andrew Eisenberg. I'm sorry.
Hi. So my question relates mostly to showing a video to a jury pool on implicit bias. I think Judge Wolfert mentioned that in federal court right now, that is frequently done. And I know in the New York State courts, there's a lot of discussion about incorporating implicit bias into jury orientation. And my question for the panel is, if that were to be done, do you think that the attorneys and the judge should also be present during that particular video, so that one, there's a constant re-educational reminder to both the bench and the bar about the issue of implicit bias, and also perhaps jurors would be able to see firsthand that it's an important issue for the court? Or do you feel that the implicit bias video should simply be incorporated right into the standard routine orientation video that's already presented to the entire jury pool summoned at the beginning of the day?
I'll give it a shot to answer the question first. I think the videos that I'm aware of are designed to be shown with the general orientation videos that the prospective jurors see when they're with the jury administrator before they get brought down to court. I think it's important, though, for there to be follow-up questions on that topic during the voir dire. So it's obviously important for the judge and the attorneys to be aware of what the content of that video is, so that then appropriate follow-up questions can be explored during voir dire. That's my perspective, at least.
Well, my perspective would be, I don't know how you get the judges. It is the time. Time is a factor in the jury selection process. I think the judges should see it, but whether or not they are going to allow that time to be taken to view it again becomes another issue. So I think it should definitely be shown, just like the other movie is, to the entire prospective pool. But you know, it's up to each individual judge to do their own educating, whether it be in the form of preliminary instructions or something else. But if you can get a judge to take the additional 10 minutes to do it, then I think it would not hurt at all. But I just don't know that you get all the judges to, at least in the civil side. And the criminal part, I think surely the judges and the lawyers should observe the should observe the movie. But again, it's a timing factor. And time is money.
I want to jump in with another sort of moderator's question, so we don't leave out the practitioners whose perspectives were just so helpful on the panel. And that is just reflecting on one of the answers that Judge Wolford gave, that Batson is not the most effective tool for sussing out implicit bias, which makes sense for all kinds of reasons. That leaves us with very little with respect to a certain kind of bias, and that is on the part of attorneys. Now, Batson applies to defense attorneys as well as to prosecutors. And of course, it doesn't target the racial or implicit racial biases of the jurors, but it does of the attorneys. And that puts attorneys in very uncomfortable positions, right? I couldn't imagine, I've never served as a prosecutor, but I could imagine it being very uncomfortable to have to call to account if a Batson challenge is raised and one is accused of lying about their true motives. So I guess with that in mind, I guess maybe Ms. Tucker, for someone who is trying to select a jury that is impartial not only to the government but also to the people, how do you react? Have you been in the position of facing a Batson challenge? What are some situations in which your motivations for using a peremptory strike might be misconstrued, and how do you address those?
Actually, I think it might be a little different for me. That, the first time there was a Batson challenge, it was almost, for me, it was a little comical because the defendant was actually white, and so was his attorney. So the fact that he made a Batson challenge because I moved to dismiss a Black juror was a little bizarre. But I really could count on one hand the amount of Batson challenges that have been made against me. And I can only speak for myself and not for all prosecutors. I welcome minorities on my jury. I think the more diversity there is on my jury, that's great. But again, I have to reiterate that I don't control the panel of jurors that is brought into my room. And I think from some stats from 2019 that I was discussing with Christine Farrow, of something almost 11,000 jurors that served in 2019, 87% of those jurors were white. So if I have two minority jurors on any given jury, that's a good thing for me. That's a lot. And, there just isn't the numbers that are there. But I really haven't had issues with Batson challenges because I don't try to remove minorities, really, unless there's explicit bias, because Batson is, the answer to a Batson challenge is to provide a race neutral reason for that challenge. So, why is it just the word race and not gender or age or, disposition or political affinity, whatever it is, why is it just race? So, again, if you craft your questions properly during jury selection, and you properly dismiss jurors that are explicitly biased, or for other good reason, then, you really don't come up against that Batson challenge often. But I would also suggest that because I am a woman of color, that perhaps those challenges are made less against me than they are against my white colleagues.
Great. And Robert, I want to ask from your perspective on the other side of the circumstances under which you've raised Batson challenges, what sort of arguments do you make to try to suss out pretextual from non-pretextual reasons, and what sort of situation sense do you use in these contexts?
Well, I have made Batson challenges in federal court and in state court. However, it is, as Judge Wolford says, in also Judge Ogden has noted, it's a heavy road to hoe. I mean, it's difficult to overcome that. You as a defense attorney and your client, both, I'm an African American male, so there's an implicit bias because I'm African American and I'm a professional. So I have to overcome that as well from jurors. But when we start removing certain jurors, and let's just take the example of African Americans, and I have an African American client, the question then becomes, well, why did you remove that person? If that person has given every answer to show that they are unbiased, that they will reserve the right to make their decision, they will follow the judge's instruction, why did you remove that person? Other than the fact that that person is Black. Well, sometimes it's very obvious, but that response and that argument is insufficient to hold the day. It's just insufficient. And there has to be some race neutral way that the government or the prosecutor remove that person. And it's easy to make that argument because this person has an affinity against the police. So therefore, that's the reason why we remove them. Because this person has been involved in crimes before and was arrested before. So that's the reason why we remove them. So there are many reasons why a prosecutor could attach their otherwise implicit bias to a very legitimate reason, which I really can't combat, because now I have to go into the mind and the heart of the prosecutor and then pull that out to say, well, you have implicit bias. So it's very difficult to do that, especially when you do have African Americans who have been or can be seen as being in high crime areas or have been confronted by the police. But see, those two notions themselves denote, or at least suggest, the implicit bias that should be grounds enough to bring about a Batson challenge, but it never really does, because we can't get to the explicit. And that's what the judges were saying, that Batson rule is not a good rule to address the implicit bias that is inside of me, inside the prosecutors, inside the judge and the jury. It's impossible to use the Batson rule to actually address that. The only thing you can do is be clever enough to ask the right questions, to draw upon the implicit bias and have it explicitly shown. Once that's happening, then a Batson rule can win the day, but typically it doesn't, because we all are sort of trained to seek out fair jurors for both sides, for the prosecution and for the defense. That's the ultimate goal of the litigators on the prosecution side and the defense side, is to find a fair jury that will not favor the defense or the prosecution and will simply listen to all the evidence and wait until they get their instructions from the judge.
Wonderful. There are a few more questions in the chat, all of which are very good. I think that what I would like to do is invite any of the panelists just to react to one another or anything that anyone said. And to the extent that they don't have anything to say, we can address at least one of the questions, which is what ideas are there about specific effective questions that might draw out implicit biases. So you may answer that question, anyone on the panel, or we can just have a quick Quaker style moment of silence until somebody is moved to react to something anyone else said on the panel.
Can I say something? I was a prosecutor and I am an African American, and I removed African Americans that I thought that would, when I was a prosecutor, that would relate to the defense, because I viewed that as my job to get a jury that was likely to go along with my side. When I was a criminal defense lawyer, I would remove people who I didn't think were going to go along with my side. And I don't know that it was implicit bias. It was just, that's what I wanted to do in order to to win my case. And I think we have to factor that in along with other things that when they're real implicit biases, because I really do believe it exists, and I agree with everybody. But sometimes, you know, if I could win with a Batson challenge, I'd make that challenge. Whether in my heart I believe that, I don't know. And perhaps that's an ethical issue. Now, as a judge, I knew I did some of those things, so I call the lawyers out if I think that's what they're doing.
May I add something real quick?
Please.
As an African-American defense attorney, I will tell you that you need to be careful about what you wish for, because I'm going to tell you that not all African-Americans can be placed in the same little pool. Sometimes the worst jury or the worst juror will be an African-American for an African-American defendant, because a lot of times we hold ourselves at a much stringent level of, I guess, scrutiny than non-African Americans. So sometimes we also have an insight to a processes or a community or the way people think, and that African American may not be the one that you should be asking for. And you, as an African American male or female litigator, should remove them because of that implicit bias which they hold. But just like the judge said, the object is to get jurors who favor my case. I don't care why.
This is wonderful. And I think that we have time for one more question. And I would like to give the privilege of last question to one of the committee members who organized tonight's panel. And with thanks to him and to the rest of the panel for organizing. And that is Oliver Young.
Thank you. And this question probably for the litigators. And would the elimination of peremptory challenges result in say, a less biased jury? As Robert was suggesting, sometime when you're picking a jury and you get that juror that's on there that you believe is on your side, and that person gets struck by the prosecutor. And you may have gotten into the situation where you run out of peremptory challenges, and so you're stuck with jurors that you believe might harbor some kind of bias, some kind of stereotype that might be negative to your client, your defendant. So, what do you think about that? That's been discussed in the literature for some time now about peremptory challenges and a new way of picking our jury.
Oliver, that's a very thoughtful question. It scared me, just the thought of having no peremptories, because you're absolutely right. You know, we don't always get a chance to speak to all the jurors or to ask all the questions or flesh out all the issues that we want to flesh out. And, you know, for me, as I said, it's a gut instinct. It really has nothing to do with the color of their skin. It's the way that they're answering the questions or not answering the questions or staying very quiet or giving, you know, single one-word answers to my questions. So I don't know. I mean, it's all very connected to implicit bias. You know, if you get rid of the peremptories, then you need to be able to flesh out the implicit bias in some other way. So I don't know the answer to that question, but it's food for thought.
Yeah.
Well, I guess I can chime in. I think removing peremptory challenges is a double-edged sword, and it has a different effect in different jurisdictions. For example, I would want to keep my peremptory challenges if I'm in federal court, because I don't get a chance to address the jurors unless the court gives me an opportunity to do so. So therefore, the only thing I can do is kind of, as Judge Wolford said, I do present questions to the trial judge. And my questions a lot of times start off in the range of race relations, because there may be an African-American male who's accused of trafficking drugs and a white young female dies. And now if we have a whole white jury, then I need to flesh that out. So I would give questions, but then I'm not allowed to ask any other questions unless I'm allowed to address the court and the court allows that to happen. Sometimes I'm allowed to address it directly, but that's limited. And sometimes the judge will craft the question. So a peremptory challenge in federal court, to me, is a necessary tool that I would have to have. Peremptory challenges in state court, well, I could say to remove the peremptory challenge in the state court will force each attorney, prosecution and defense, to be more crafty in developing questions and become more, focused on drawing out, at least bringing to the surface that which is implicit and make it explicit. So this way they can win the day on their challenge for cause. Now, I think that is a great exercise, but you got to see the biggest problem that we have is not necessarily the implicit bias of the litigators in using the peremptory challenge. It's the implicit bias actually in the prospective jurors that we still need to draw out. So removing the peremptory challenge could actually hurt us, because in the state court proceedings, even if we ask these questions, jurors tend to hide or not tell the complete truth. So therefore, we may never get a true reading of the implicit bias and can only resort to our understanding or our feeling and then use the peremptory challenge. So like I said, it's a double-edged sword. In one jurisdiction, it could be beneficial. In the other jurisdiction, it would be a curse for defense attorneys to have that removed.
Thank you. I wish we could have this conversation continue for 2 hours longer, but we are out of time. I want to thank the organizing committee once again, and thank the panelists for this incredible conversation. Eileen, do you have any last words to close us
Yeah,
out?
I want to thank you, Tony, for leading this important conversation. You were great, and the panelists were also great. Please be sure to save a copy of our CLE materials, popularly known as the Johnson Report. It's a review of court system policies, practices, and programs aimed at advancing equal justice in New York. On Wednesday, March 24th, we will be Zooming 2 CLEs, RBG's Greatest Hits, in conjunction with the Western New York chapter of the Women's Bar Association, and a Gold Group CLE, New York Speedy Trial in the Age of COVID-19 and Civil Rights Law Section 50, a discovery update. Details for both are on our website. Thank you for attending tonight's program. Thank you again to our fabulous panelists and our wonderful moderator. Good night.
Thanks, everyone.